Navigating Section 9 of IBC, a comprehensive guide for operational creditors. Welcome to our comprehensive guide on Section 9 of the Insolvency and Bankruptcy Code, IBC, 2016. Today, we'll delve into the critical aspects that operational creditors need to understand to effectively initiate a corporate insolvency resolution process. The Path to Insolvency Proceedings, a guide for operational creditors. Before we delve into the procedural steps outlined in Section 9 of the IBC, let's clarify who is an operational creditor. According to business lexicons, an operational creditor is typically a vendor or supplier that provides goods or services to a company and is awaiting payment. However, the IBC gives it a precise legal framework. Definition of an operational creditor. As per Section 5(20) of the Insolvency and Bankruptcy Code 2016, an operational creditor is defined as a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Understanding operational debt. To further understand, Section 5(21) defines operational debt as a claim in respect of the provision of goods or services including employment or a debt in respect of the repayment of dues arising under any law for the time being in force and payable to the central government, any state government or any local authority. Identifying default and issuing demand notice. With the definition clear, we now know that when such operational debt is due and unpaid, the operational creditor is entitled to initiate an insolvency resolution process. This process begins with identifying a default and issuing a demand notice as mandated by Section 8 of the IBC. Dissecting the 10-day notice period under Section 9 of the IBC 2016. When an operational debt remains unpaid, the operational creditor can use a powerful mechanism provided by the Insolvency and Bankruptcy Code, IBC, 2016, the 10-day notice period. But what does this entail, and how must it be meticulously crafted to meet legal standards? Crafting the demand notice. The demand notice, often served as a demand letter or invoice, is not merely a formality. It's a document meticulously structured to establish the credibility of the claim and to lay the groundwork for potential insolvency proceedings. Critical components of the notice. The notice must include 1. The exact amount of debt owed. 2. Detailed account statements or invoices. 3. The timeline of the debt. 4. Any previous correspondence regarding the debt, and 5. A clear declaration of intent to initiate insolvency proceedings if the debt remains unsettled. Proof of delivery, ensuring the debtor is aware. Equally important is the proof of delivery. The creditor must ensure that the notice is delivered through a trackable medium, securing evidence that the debtor has been adequately informed. Monitoring the debtor's response. Within this period, the operational creditor monitors any form of acknowledgement or dispute from the corporate debtor. The absence of a dispute or a payment within this window authorizes the creditor to proceed legally. Legal nuances of the notice. It's imperative that the notice also complies with the format and content as prescribed in the IBC regulations. Any deviation could jeopardize the creditor's position or delay the process. Deadline for the corporate debtor. The 10-day period is a deadline for the corporate debtor, a final opportunity to discharge the debt or to bring forth a dispute. Ignoring this notice signals the debtor's inability or unwillingness to pay, thus strengthening the creditor's case for initiating insolvency. Strategic planning by the operational creditor. In the interim, the operational creditor might engage in strategic planning, including consulting with insolvency professionals, and collecting additional evidence to support their claim if the matter escalates to the insolvency tribunal. Anticipating a dispute. If a dispute is raised by the debtor, it's not the end of the road. The creditor needs to assess the validity of the dispute. An insubstantial dispute won't stall the insolvency process under the IBC. Post-notice steps, beyond the 10-day window. After the 10-day period, should the creditor need to proceed with an application for insolvency resolution, they must prepare a comprehensive filing. This includes the demand notice, proof of its delivery, evidence of non-payment, and the absence of dispute. With all the ducks in a row, the application can be lodged with the adjudicating authority, marking the transition from creditor patience to affirmative legal action. Filing an application to initiate insolvency. When a corporate debtor does not clear the due debt within the 10-day window following the demand notice, an operational creditor can move to the next crucial phase, filing an application to initiate insolvency proceedings. To ensure due diligence, the application must meet certain prerequisites. It must be filed in the form prescribed by the Insolvency and Bankruptcy Board of India, known as Form 5, which captures all necessary details of the debt in question. Mandatory documents for application submission. Accompanying documents are the backbone of the application. These include 1. A copy of the invoice demanding payment or notice served to the debtor. 2. An affidavit that the debtor has not disputed the claim. 3. A copy of the certificate from the financial institutions confirming there is no payment against the invoice, and 4. A proof of the operational debt owed. The creditor must also ensure that the application is complete with evidence to prove the existence of the operational debt and the default. Additionally, it should include the proposed resolution professional's details to manage the insolvency proceedings. Payment of application fee. A non-refundable fee is required to process the application. This fee is determined by the amount of the claim and must be submitted along with the application form. Once the application is submitted, the adjudicating authority, within 14 days, ascertains the positions of both parties. It either admits or dismisses the application based on the completeness of the documentation and the existence of a default. Awaiting the adjudicating authority's decision. Should the authority admit the application, the insolvency resolution process commences, bringing us to a pivotal juncture where the operational creditor seeks redress through legal means. It's imperative for the operational creditor to adhere to every detail of the application process, as any oversight can lead to dismissal, potentially affecting the recovery of the operational debt. Detailed documentation requirements. When an operational creditor approaches the precipice of initiating corporate insolvency resolution proceedings, the arsenal of documentation they must furnish is not just procedural, it's the foundation of their case. Mandatory documents. Let's dissect these mandatory documents, understanding their substance and significance in the eyes of the law. 1. Invoice or demand notice. The invoice or demand notice is the operational creditor's opening gambit. Not merely a piece of paper, it's a formal declaration of debt, a proclamation that an obligation exists and has been communicated but remains unfulfilled. 2. Affidavit confirming no dispute. The affidavit of no dispute is not just a document, it's a shield against the debtor's potential defense of a pre-existing dispute. It's an assertion, under oath, that no contention clouds the dues in question. 3. Certificate from financial institutions. The certificate from a financial institution might seem like a mere formality, but it serves as a testament from an entity perceived as neutral, validating the operational creditor's claim that the debt stands unpaid. 4. Record with information utility. A record with an information utility, if available, is the new age evidence, a digital confirmation cutting through paperwork to showcase an undisputed claim of non-payment. 5. Additional proof of non-payment. The creditor may also need to present additional evidence, such as bank statements, ledger extracts, or communication records, to seal the narrative of non-payment and close any gaps that could be exploited. Resolution professional proposition. Proposing a resolution professional is akin to choosing a champion for the impending resolution battle. It's a strategic move, proposing someone deemed fit to steer the debtor company through troubled waters, towards a possible rebirth. Every piece of paper, every record, serves a purpose beyond its text. Together, they construct an operational creditor's fortress of claims, within which they stand to assert their rights. It's through the meticulous compilation of these documents that an operational creditor arms themselves, not just with evidence, but with confidence as they step into the legal arena of insolvency and bankruptcy proceedings. In-depth look, proposing an interim resolution professional. In the intricacies of the insolvency landscape, an operational creditor who has not received payment has a significant card to play. This move is the proposition of an interim resolution professional, or IRP. Eligibility criteria for IRP. Let's peel back the layers on who can be this crucial player. The code specifies that an IRP should be an independent professional, registered with the Insolvency and Bankruptcy Board of India. They should not only carry expertise in handling financial affairs but must also have a clean track record, devoid of any disciplinary action. Influence on corporate debtors' future. Why does the role of IRP carry such weight? Upon appointment, the IRP assumes control of the debtor's enterprise. They replace the existing board of directors and take charge of the company's operations. Their decisions will steer the future course of the business, holding in their hands the power to potentially rescue or liquidate the corporate entity. Proposition process. In proposing an IRP, an operational creditor initiates a tactical play. They must file an application in the format prescribed by the IBC, attaching a proposal for the IRP along with the creditor's affidavit. This is a testament to the trust placed in the IRP, who will stand in the operational creditor's shoes, to some extent, during the resolution process. Scrutiny by adjudicating authority. The proposed IRP is not guaranteed the position. The adjudicating authority, typically the National Company Law Tribunal, scrutinizes the proposal to ensure the nominee is devoid of any biases and conflicts of interest that could jeopardize the fairness of the insolvency process. Transitional authority. If approved, the IRP becomes a transitional authority, but with a finite mandate. They oversee the company only until the Committee of Creditors, comprising all creditors to the corporate debtor, convenes and decides either to ratify the IRP's position or appoint another resolution professional. Strategic considerations. For an operational creditor, the proposal of an IRP isn't a mere procedural step. It's a strategic decision, with profound implications. The right professional can negotiate effectively with creditors, manage day-to-day operations efficiently, and most critically, chart a course of action that maximizes the chances of reviving the corporate debtor, thus safeguarding the creditor's interests. Deep dive: Adjudicating Authorities Examination under IBC 2016. In the intricate ballet of insolvency proceedings, the adjudicating authority plays a pivotal role, far beyond a mere administrative checkpoint. It is entrusted with a task that is fundamental to the integrity of the entire process. Comprehensive scrutiny, beyond the surface. Upon receiving an application from an operational creditor, the authority's first order of business is a thorough examination. This goes beyond the prima facie review of documents. The authority delves into the intricacies of the claim, examining the nature of the operational debt and verifying the creditor's entitlement. Verifying the demand notice, ensuring due process. A critical element under the IBC is the demand notice served by the creditor. The authority meticulously verifies its issuance and the debtor's response, or lack thereof. This notice is not just a formality but a legal requirement that could determine the course of the application. Assessing the debt, establishing the obligation. Establishing the debt's existence is paramount. The IBC mandates this without ambiguity. The authority examines the operational debt's documentation, contracts, ledgers, invoices, seeking irrefutable evidence that the debt is due and payable and not mired in a substantive dispute. The dispute conundrum, unraveling complexities. And then, there is the question of dispute. What qualifies as a dispute under the IBC? The authority must unravel any assertion of dispute by the debtor, distinguishing bona fide disputes from mere delaying tactics. It's a fine line that demands acute judicial discernment. Decision dynamics, the path forward. The outcome of this evaluation is binary, but the consequences are far-reaching. Admission of the application can lead to the committal of the debtor to a collective insolvency process, altering its very future. A rejection, while less dramatic, sends a clear signal: the creditor must look elsewhere for recourse. Time is of the essence, the statutory deadline. All this, under the pressure of time. The statutory 14-day deadline is more than a procedural formality. It reflects the code's commitment to timeliness and efficiency. Any delay could diminish the value of the debtor's assets and undermine the code's objective of time-bound resolution. Judicious wisdom, balancing interests. The authority's role is not just to enforce the law but to balance the scales between the creditor's rights and the debtor's interests, ensuring fairness and upholding the sanctity of the legal framework. It is a testament to the responsibility that the IBC vests in the adjudicating authority. As guardians at the gates of insolvency resolution, the adjudicating authority's decisions are not just about admitting or rejecting a claim. They are about steering the precarious journey of a debtor in distress, while safeguarding the interests of the creditor, a duty they discharge with the wisdom and urgency that the code demands. Key case laws interpreting Section 9 of the IBC. In the realm of corporate insolvency, understanding precedent is paramount. The 10-day notice period and the conditions under which an operational creditor can initiate the corporate insolvency resolution process, CIRP, have been subject to various judicial interpretations. Here are some relevant case laws that discuss the 10-day notice period and related provisions. Mobilox Innovations Private Limited vs. Kirusa Software Private Limited. A landmark judgment that set the precedent for what constitutes a dispute came from the case of Mobilox Innovations Private Limited vs. Kirusa Software Private Limited. The Supreme Court clarified that for a dispute to exist, it must be pre-existing, before the receipt of the demand notice or invoice, and not a subsequent concoction. This decision underscored the necessity for operational creditors to ensure that their claims are undisputed and crystallized. Innoventive Industries Limited vs. ICICI Bank and ANR. In the case of Innoventive Industries Limited vs. ICICI Bank and ANR, the court observed the sanctity of the timelines prescribed in the IBC. The ruling reinforced that if an operational debt is due and payable and is not repaid within the stipulated period, the insolvency process can be triggered, providing clarity on the adherence to the strict time frames set by the code. Macquarie Bank Limited vs. Shilpi Cable Technologies. In Macquarie Bank Limited vs. Shilpi Cable Technologies, the Apex Court dealt with the technicalities of serving a demand notice under Section 8 of the IBC. It was established that an operational creditor can deliver the notice either to the registered office of the corporate debtor or at the corporate debtor's email address, as was the practice in this particular case. This judgment highlighted the flexibility and modern approach embedded within the IBC's mechanisms. Smart Timing Steel Limited versus National Steel and Agro Industries Limited, NCLAT. In this case, it was decided that if an operational creditor fails to provide a copy of the invoice or a notice for payment to the corporate debtor, this could invalidate the application for insolvency even after the 10-day notice period has elapsed. K. Kishan vs. M. S. Vijay Nirman Company Private Limited. Supreme Court. The Supreme Court in this case dealt with the aspect of a dispute existing before the demand notice was issued. It was held that if there is a pending arbitration proceeding, it could be construed as a pre-existing dispute, and therefore, an application under Section 9 of the IBC may not be maintainable. Aloysman Industries vs. Raman Casting Private Limited, NCLAT. In this case, the NCLAT ruled that mere service of a notice by an operational creditor without delivering the goods for which the payment is being sought does not entitle the operational creditor to invoke Section 9 of the IBC. Amplifying legal understanding for operational creditors. These judgments are instrumental in amplifying the legal understanding for operational creditors. They serve as critical navigational beacons in the intricate voyage of insolvency proceedings. Operational creditors, armed with these judicial interpretations, can better safeguard their interests and navigate the procedural intricacies with enhanced clarity. These case laws serve as the guiding stars in the IBC's constellation, ensuring that the process is just, equitable, and in line with the principles of natural justice. We've meticulously dissected the role and journey of an operational creditor under Section 9 of the Insolvency and Bankruptcy Code, IBC, 2016. This voyage started with a clear definition of an operational creditor and the nuances that differentiate them from financial creditors, ensuring clarity right from the foundation. A crucial component of this process is the 10-day notice period following a default, which demands strategic action from creditors, including the delivery of a meticulously drafted demand notice. The subsequent application to the adjudicating authority is not just about filling out a form, it's a careful compilation of documentary evidence, affirming no existence of dispute and ensuring the debt's legitimacy. We also spotlighted the significance of proposing an interim resolution professional. This is not just a procedural formality, but a pivotal move that can influence the trajectory of the resolution process. The adjudicating authority's role, bound by a strict 14-day window, is the fulcrum on which the wheels of justice balance the interests of the creditor against the sanctity of the corporate debtor's right to a fair insolvency process. Diving deeper, we navigated through landmark case laws that serve as beacons, guiding the application of Section 9. These judicial pronouncements are not merely verdicts but lessons carved out of corporate skirmishes, each adding layers of interpretation and precedent to the IBC's evolving jurisprudence. As operational creditors, your actions are the keystrokes in the symphony of corporate insolvency resolution. Knowledge of your rights and obligations, a clear understanding of the IBC, and the strategic utilization of this legislation can orchestrate successful outcomes for your claims. While this video serves as a foundational guide, the complexities of real-world scenarios require personalized legal counsel. I urge you to arm yourself with the power of expertise. Seek out professional legal advice to navigate the intricate labyrinths of insolvency and bankruptcy proceedings. To continue refining your understanding of such critical topics, please like this video, subscribe to our channel, and share this resource with your network. Your support helps us create content that empowers you with knowledge.